Okay, let's talk about the US Constitution. I mean, this is the ultimate rule book for the country, right? And it was written over 230 years ago. So, what happens when a country kind of outgrows its own rules? Well, today, we're going to dive into exactly that. We're going to look at the incredibly difficult, almost puzzle like process the founders created for changing it.
No, seriously, think about it. How do you change a country's most important document? It's not like your phone where you just, download an update. This thing is the bedrock. It's the foundation for our entire government, all of our rights. Changing it, it's like trying to perform open heart surgery on a system while it's still running. So the big question is, how did the founders build a way to adapt without just breaking everything?
You know, the framers faced this massive problem. They were brilliant, for sure, but they couldn't see the future. They had no idea what was coming. They knew the world would get, well, weird and unpredictable. So they needed to create a document that was basically rock solid, something you could build a nation on, but not so stiff that it would just snap under pressure. And what they came up with? It was an absolutely ingenious balancing act. And that balancing act, that solution, we find it in one specific place, Article V. You can basically think of it as the how to update chapter in the Constitution's instruction manual. It lays out this very deliberate step-by-step process. And it was designed for one big reason, to make absolutely sure that any change wasn't just some passing political fad, but something that, the overwhelming majority of the country was truly on board with. So, what's in this instruction manual? Well, it all boils down to two big steps, two major hurdles. First, an idea has to be officially proposed, just put on the table. But then it has to get through the second, and frankly, much harder stage, ratification. That's where the states have to give it their final stamp of approval. Every single amendment we have, all 27 of them, had to survive both of these stages. All right, so let's break down that first hurdle, the proposal stage. This is the moment an idea for a change goes from being just, talk and debate to becoming an official item on the national agenda. And believe me, just getting to this point is a huge, huge challenge. So Article 5 actually gives us two different ways to get an amendment proposed. The first path is the one we've always used. It goes through Congress. An amendment has to get a 2/3 vote in both the House and the Senate. That's a supermajority. But then there's this other path, this sort of break glass in case of emergency option. If 2/3 of the states get together, they can force Congress to call a national convention just for proposing amendments. And what's wild about this is that second option, it's been there the whole time, like a tool in the back of the shed that no one has ever used. And just pause on that number for a second. 2/3. We're not talking about a simple 51% majority here. This isn't about just squeaking by with one extra vote. This number forces a massive, broad consensus. The founders picked it on purpose. It was designed to be a filter, to weed out any radical ideas or, just the political flavor of the week. It ensures that only the most essential, widely supported changes even make it to the starting line. Okay, so let's imagine the impossible happens. An amendment actually makes it through Congress with that 2/3 vote. It's officially proposed. So, is it law now? Nope, not even close. In fact, the hardest part is just beginning. Now it faces the final and even tougher hurdle, ratification. And just like before, there are two possible paths to get this done. But this time, it's Congress that gets to pick the route. The usual way, the way it's almost always done, is to send the proposed amendment out to all 50 state legislatures for them to vote on. But there's another option, which has only been used once. Congress can ask each state to hold a special convention just to vote on that one amendment. Whichever path they choose, the finish line is still really, really far away. And here it is, the final boss of the amendment process, 3/4. Let's put that in perspective. That means 38 out of 50 states have to agree. 38! This is the ultimate safeguard built into the system. It's there to make sure an amendment isn't just popular with one party or in one part of the country. To pass, it has to have genuine, overwhelming, coast-to-coast national support. And the moment that 38 state says yes, it happens. The amendment becomes, and I'm quoting Article 5 here, valid to all intents and purposes as part of this Constitution. Just let that sink in. It's not just a new law that can be repealed later. It is literally woven into the fabric of the original document. It has the exact same weight, the exact same power as the words written by the founders themselves. Okay, so that's the how. We've walked through the whole obstacle course. But now for the big question. Why does any of this matter today? Well, it matters a lot, because the sheer difficulty of this process has huge consequences for how we run the country and how we argue about our biggest problems. On the one hand, this super tough process gives us something really valuable: stability, right? The fundamental rules of the game don't just change every time there's an election. But there's a massive trade-off. Because when we run into modern problems that the founders couldn't possibly have imagined, things like the internet or complex social issues, changing the Constitution to deal with them is basically off the table. It's just too hard. So what happens? Where do all those fights go? Well, they spill over into the courts. And suddenly you have judges trying to figure out how words written in the 1700s apply to the world we live in today. And I want to be really clear, this isn't just some abstract, historical debate. This is the engine driving some of the biggest, most passionate arguments happening in America right now. Think about it. Debates over executive power, who gets to be a citizen under the 14th Amendment, what free speech even means on the internet, or the role of the Supreme Court itself. All of these intense fights are happening because it's so hard to change the actual words of the Constitution. So instead, we're forced to have these huge arguments over what those old words mean today. Which really leaves us with this one giant question. The founders clearly wanted stability more than anything else, but we live in a world that's changing at a speed they could never, ever have imagined. So is that trade-off still worth it? Is this difficult process a shield that protects our core principles, or has it become a cage that stops us from moving forward? That right there, that's the fundamental tension at the very heart of the Constitution.